A very warm welcome to everyone to today's discussion on the topic Arbitration and Mediation Capacity Building in India. My name is Pallavi Agrawalla. I'm an associate at MRP Advisory and I will be the moderator for today's discussion. Before we begin, let me take a moment to introduce our speakers. First, we have Mr. Corrado Mora, an international mediator with 20 years of experience handling complex cross-border disputes. He is a fellow of the Chartered Institute of Arbitrators, a CEDR accredited mediator, and a faculty member for ADR, conflict management and mediation training worldwide. He advises global organizations, including the UN, UNDP, USAID, and the European Patent Office. He is also empaneled as a mediator with the International Arbitration and Mediation Center at Hyderabad in India. Welcome, Corrado. Next, we have Ms. Shweta Srivastava. Next, we have Ms. Shweta Srivastava, Associate Director at Masin, a global business advisory, consulting, and expert witness firm. She has over 9 years of experience in tendering, bidding, estimation, business development, and construction management. She has managed projects across various sectors, including NPK fertilizer plants, oil and gas projects, and real estate ventures with budgets ranging from 50,000 to $1 billion US. Welcome, Shweta.
Thanks for having me.
We also have with us Ms. Shilpi Mehta, who is currently an assistant professor at Bhagwant University, Ajmer. With over 8 years of experience across industries, Shilpi has also served as an in-house counsel with a leading German-based company in India, and her career includes roles in a prominent media house and an edtech company specializing in content development and legal education. Shilpi has consistently engaged in capacity building, contributing to knowledge dissemination and mentoring future legal professionals. Welcome, Shilpi. Thank you. Finally, we are joined by Mr. Nikhil Ramdev, Senior Associate at MRP Advisory. He is a specialist in international dispute resolution with over 8 years of experience in construction arbitration and commercial litigation. He has extensive experience in drafting pleadings, client counseling, investigations, and cross-examination preparation. He leads multi-million-dollar international arbitrations in the Middle East and practices before the Supreme Court of India, the Delhi High Court, arbitral tribunals, and other fora. Welcome, Nikhil.
Thank you, Pallavi.
Now, coming to our topic for today, we have all been witness to how arbitration and mediation have emerged as effective and preferred modes of resolving dispute, offering parties control over the process, confidentiality, and cost effectiveness. This growing importance of ADR mechanisms, particularly in commercial and infrastructure sectors, highlights the need for a robust framework for capacity building. The focus today shall be on exploring how India can bridge the gap between theoretical knowledge and practical application to develop a skilled pool of arbitrators, mediators, and other ADR professionals, including technical experts. Without further ado, I would like to present my first question to Corrado. Speaking of capacity building, Corrado, your experience as a mediator and university trainer offers a unique perspective. How do you see the current gap between academic training and practical application in mediation, particularly within university settings? Over to you.
Thank you. Well, it is a very interesting question because, first of all, university training on mediation and negotiation is already something that should be improved all along. It is two topics which are definitely to be kept into programs. Universities all around the globe are improving their promotion of these kind of courses, but still many things have to be done. Then the main characteristics of these trainings and topics are differently from other topics that are currently into the programs of universities, where you have a strong academic contents, and the knowledge which you share with students is mostly based on books, laws, or somehow things that are in writing. When you talk about mediation and negotiation and arbitration, what you strongly have is practice, which is then crystallized into best practices, techniques. So you can't really escape from keeping strongly connected what it is academic and what it is practical. You can't really have a honest training, not just at the universities, but also generally speaking, training for mediators or negotiators or arbitrators, which doesn't keep this strong connection in mind. This means that it is not just the academic world that has to deal with training these kind of subjects at the universities, but there must be a strong connection with the practical worlds of mediators and arbitrators. I personally have these very good results and in mind. I just come from assessing some mediation and negotiation competitions. And what you had were students coming from this kind of training where they combine the academic and the practical world, which is something very strong. Of course, it is a matter of bonding together the right universities, the right professional background from mediators, and have all these available for the students. Sometimes it can really incur into costs for having international mediators moving to universities. But for sure, it can be worthy and can establish these ability to give the students honest and right side on what happens within a mediation or arbitration room, which is something that can change from situation to situation. You really have to dig into the specificities of the case scenarios, not just the main techniques which are written on books.
That's an insightful perspective, Corrado. Thank you for sharing. My next question is directed to Nikhil. Considering the Indian government's efforts to promote mediation and arbitration, could you highlight some of the initiatives and their impact on ADR in India?
Thank you, Pallavi. Certainly, in the last decade, Government of India has been very proactive in the sphere of mediation and arbitration. The purpose is to strengthen India's ranking in ease of doing business. And while doing so, one of the key indicators is enforcement of contracts. And the ADR mechanism substantially help in reducing the backlog of litigation and enforcement of the contracts. Therefore, in the last decade, Government of India has taken substantial proactive measures in via legislative amendments and policy initiatives. On legislative front, Government of India has substantially modified the Arbitration Act with amendments in 2015, 19, and 20. Even recently, 2024 draft amendment bill has been published by Government of India, recommending sweeping changes in the arbitration landscape, which are in line with international best practices. So, for example, in this bill, the Government of India is giving statutory recognition to emergency arbitrations in Indian seated arbitrations. The draft bill has introduced various time limits aimed at expediting the decisions by court. For example, Section 8 and 11 must be decided within 60 days. Jurisdictional objections must be decided within 30 days. Now, with regards to mediation, in the last decade, Government of pre-mediation before filing of suit has been made mandatory in commercial courts by Commercial Courts Act. Further, India signed and ratified Singapore Convention on Mediation. On top of it, Mediation Act 2023 was enacted. It strengthens the enforcement of mediated settlement agreements in India. Government of India introduced a domestic public procurement policy where it suggested that arbitration may be restricted to disputes below 10 crores, and for above 10 crore of dispute, mediation must be encouraged as per the Mediation Act 2023. One of the very big policy decision was by Government of Karnataka, wherein they withdrew compulsory arbitration clause from its tenders. So the impact is that it will promote court annexed mediations. Therefore, the government's focus is on institutional arbitration and mediation and to make it a hub for ADR. Thank you.
All right, Nikhil. Thank you for sharing these developments. I would now like to ask Shilpi, how are current law school curriculums in India addressing the need for arbitration and mediation expertise? Please share your thoughts on the areas that need more focus.
Thank you for your question. Uh, since I'm directly involved in universities and directly in connection with students, I would give you an insight specifically to my region, that is Rajasthan. What has happened over a period of time, I've realized that though ADR has gained a boom in the recent years, but then it is very specific to some states of India. When you talk about developed states, when you talk about Delhi or states like Bangalore, where you have corporates, there I think ADR has boomed many folds. But when you talk about states like Rajasthan, the universities are still coping up with these facts or including them into their syllabus or curriculum has been a challenge, because we do not find corporates here the way they are functioning in Delhi or Bangalore or these big metropolitan cities. That has led to students not being involved or interested in ADR at all because they don't have the exposure for it. Though universities at their level are trying their best, but then it strictly remains academic. There is no practical seminars, there are no practical workshops or training centers that are provided or specifically catered to address personal training or specialized training to these students. So whenever, especially in Rajasthan, if you ask any student what they want to get into after 5 years or 3 years of law, they will only come up with two options: either litigation or going for judiciary. ADR, I don't think I've in my years of practicing as an assistant professor, I've never seen somebody come up to me and say, I want to become an ADR specialist, I want to get into arbitration. I think that has to be tackled first. The universities not only need to keep it in their curriculum as an academic subject which needs to be passed, but they should also take efforts to come up with workshops where they can have mediators or arbitrators or somebody from the fields who can specialize them or give them insight as to how much scope this fields hold. Until unless we have somebody guiding the students that okay, this is something which is coming up in India and this is already prospering in certain states, and this will come up sooner or later, it will come to Rajasthan or other states as well, then I think students, when they find scope in the field, they will definitely be interested, and further training or seminars will obviously ensure more polishing of these students because they are academically very good. But then the only thing that lacks for them to, they're reluctant to get into the field is because there's a huge gap between what they're academically being taught and what is the reality after 5 years. So what generally in the field what we hear is whatever we studied in college, nothing is happening in when we move into courts, everything is different. So that gap I think needs to be bridged. There has to be some sort of training or specialization at the university or college level itself, and compulsory internships, of course, that ensures that this gap, all of a sudden the change of atmosphere that comes from college to when they actually reach out in the field, I think that needs to be bridged, and ADR should be involved in that prospect.
Thank you for sharing your insights, Shilpi. I think this highlights the importance of talking about this, like the current session that we are having. I would like to take this chance to shift our focus to the role of experts in area. Shweta, as an expert in construction management, how do you see the role of expert in mediation and arbitration? It would be helpful if you could also outline the key differences between preparing a claim for arbitration and mediation.
Thank you, Pallavi. Firstly, both mediation and arbitration are distinct processes and their outcomes are quite different. So, mediation is basically focused on having a mutually agreed solution for the parties, and the outcome of it is not usually legally binding. However, in case of arbitration, it is more of a formal process where there are arbitrators and there are different legal documents or the evidences which are shared by way of statement of claims and defenses, and all those documents are there. And the outcome of arbitration is usually binding between the to the parties. So that's a difference. Having said that, the role of expert in both the cases will also vary. When it comes to mediation, the role of an expert, who is also called a subject matter expert, would be more of an advisory role. This person would be, offering specialized knowledge on certain matters, maybe technical matters or the industry specific issues, on which the mediator or the parties would lack some understanding. So that's the whole role of a mediator, of an expert in a mediation. His role is basically of an advisor, facilitator, so that parties can have an open communication and reach to a mutually agreed solution. So that's about it for the expert role in an mediation. When it comes to arbitration, which is a more formal and a structured process, the role of an expert is, I would say, more of an educator, basically, who would defend a particular, who would give his expert opinion on a particular matter. He would be called up by the arbitrators to give their expert opinion on the technical issues, maybe financial issues, or the other kind of issues. And also they will, and the decision of the arbitrator would be based on the expertise or the specialist knowledge, which is applied by the expert on assessing the evidence. So that's the basic difference between the role of experts for mediation and arbitration. Now, coming to the second part of it, which is the claim preparation. So, the claim preparation for in case of mediation would be more of a flexible or a collaborative way, in which the focus would be more on meeting the interest and the needs of the parties to reach a mutually agreed solution. As I told you, for example, in case of mediation, the expert would be called upon to maybe, for example, to help them understand the quality of the works which are executed on site. They would give insight on the guidelines or the standards which are available, which parties may not have full understanding of. So that is the whole way of making claims, and the role of expert in mediation. Now, for arbitration, in arbitration, the claims would be prepared in a more formal or a structurized way, where there would be legal arguments, there would be formal evidences, and all the witness statements would be there. So that's the difference between the claim preparation in mediation and arbitration. Thank you.
Thank you for sharing those insights, Shweta. My next question is directed to Nikhil. From your perspective, Nikhil, how do law firms in India contribute to capacity building in arbitration and mediation?
Thank you, Pallavi. So, as a dispute resolution lawyer, I have seen firsthand the pivotal role law firms play in fostering expertise and promoting the use of ADR mechanisms. Law firms are not just practitioners of law, they are also educators, innovators, and advocates. So, here's how we contribute to the capacity building. Firstly, as you are also part of the law firm, you are well aware about the rigorous training and mentorship programs that you have went through recently, and we regularly conduct, whether in-house workshops, seminars, or providing hands-on mentorship. Then we believe in providing hands-on experience. That is, we believe in learning by doing. So giving young lawyers the opportunity to assist in real arbitration and mediation matters allows practical experience, which is invaluable. I believe you can concur with that, Pallavi. Through knowledge sharing and publications. So this is done by organizing webinars like these, podcasts, and publishing practice notes and research papers. We also regularly collaborate with ADR institutions, law schools, bar associations, and international specialists like Mr. Corrado, so so that we can help the students in gaining perspective, and we make an ecosystem to be built for the students and professionals alike and our clients.
All right.
Thank you.
Thank you for your response. We have now seen the role of experts and law firms, but I would like to bring the discussion back to universities. And on this note, I would like to present my next question to Corrado. Reflecting on your Italian experience, Mr. Corrado, how does university education prepare students for practical mediation? We would also love to hear your insights on what can Indian universities adapt from this system.
It is a very useful question. Students today are professionals tomorrow. So, of course, you have to expand their knowledge towards fields which are not usually covered by university training. And so arbitration, ADR in general, and mediation. Here comes somehow one of the main issues with mediation training, which is you don't understand its value, its use, its effectiveness, unless you are going to go into a mediation. And it is very difficult to describe what a mediation is to someone who never had the chance to be part of a mediation. So going through university training, expanding university programs and curricula towards mediation specifically is paramount. I am very glad having been part of the University of Trento's team, where Professor Silvana Della Bontà created one exciting project 13 years ago, which is named Conflict Managers of Tomorrow, which is in fact what the title says. It is preparing students for becoming the conflict managers of tomorrow, combining more classic mediation and negotiation program and training to a laboratory where they really have case scenarios, time for simulating all negotiations and putting all this knowledge into practice and mediations too. So what you really have out of this is a large group of students that year after year gain not just the theoretical knowledge, but also practical ones, putting it into practice, and they become the conflict managers of tomorrow. We already have proofs of that, given the fact that it was the very first mediation and negotiation training happening in Italy. And the first results are that those who were the first students are now established professionals, lawyers, and mediators, and they are making the difference. So it is not just participating to international competitions on mediation and negotiation, which is part of the game and a successful part of the game. It is also, of course, preparing those who are the professionals of tomorrow, which are now the professionals of today. So our first year's students are now those who can better understand and use mediation much more than those who didn't have the chance of practicing mediation, getting in touch with mediation during their university studies. So this is the Italian experience, which is shared by the University of Trento, and then some other universities through the years started having their programs. And given its effectiveness and how it's really changing the ecosystem of those who are the professionals of the justice system in general, I would say it is not just immensely effective and useful, but it is very easily applicable to other contexts. I'm very sure that all the Indian environment and judicial system can really have strong benefits from inputting all these programs into their university curricula. It is exactly as Shilpi was saying beforehand. It is a matter of shaking the system from foundation and helping it to get it into touch with these ADR systems as soon as possible. And law schools and university studies are the very best way for professionals to get equipped starting from the very beginning. Thanks for this question.
That's a very interesting perspective, Corrado. And I hope Indian universities will incorporate more of these in the coming time. Since we are discussing on how to adapt to mediation, Shweta, do you believe claim consultants need to transition from adversarial to collaborative methods with the growing adoption of mediation?
Thank you, Pallavi. Yes, with the growing adoption of mediation in commercial disputes, this is the need of an hour basically. And this shift is very much needed because the mediation focuses on the mutually agreed solutions and it fosters communication between the parties. The role of an expert needs to shift from being an advocator to be a facilitator to help parties make a right decision, which is helping both the parties. So yeah.
Thank you for your response, Shweta. Now, I'd like to put my next question to Shilpi. Shilpi, can you please share your thoughts on how can universities foster dialogue between legal professionals and other stakeholders in ADR?
Again, this is a very interesting question because my understanding, as far as it goes, it is more of first we need to convince the students that there is a scope in this field. And then I think because the students are not well aware of it, and the teachers also are not well trained enough, because what happens is when we are reading judgments or updates in the legal field, we generally focus on Supreme Court judgments, and which are purely more or less litigation or either criminal or otherwise civil updates. Barely do we come across, or the teachers even in their curriculum or while taking classes highlight that there are developments that are happening in ADR field as such, or what are the latest trends, what are the best practices. I think till the time teachers in themselves are aware of the developments that are happening, what are the techniques, what are the recent development, critically analyzing those, I don't think till the time teachers in themselves take that responsibility to communicate the same to students, student will never actually have the interest, or will never ever develop the interest into that subject. I think that role needs to be played by the teachers more effectively first, and then communicating the same to students. Once that is done, like on a primary level, when that is done, then of course we can have seminars, we can have students who are now well informed. And if they are pass out students, they are already working in the fields, we can always bring those alumni to college, train the juniors, at the same time bring in engineers, businessmen, and people from all walks of life, come share what are the problems in their field, and whether that particular problem can be tackled by arbitration. And then we can always bring in arbitrators, mediators, or specialized people who are specializing in these fields and techniques, understand, like in a corroborative environment where we have students also, teachers also, we have all these experts also, and at the same time we have people coming in from all walks of life. In fact, even domestic disputes for that matter. When you talk about property disputes, it takes years for a dispute to get settled in India when you go for litigation. But then the same can be tackled by arbitration in a much convenient environment without getting into the heavy cost of litigation, the time consumption that is already there. I think step by step, if I have to point out, I think teachers training is the primary thing that needs to be taken care of. Then students being communicated the same over a period of time, we develop a channel or a network where we have people, as I mentioned, from all walks of life coming in, telling about the problems that they face in their field, and whether experts then suggesting that whether this problem can be solved by ADR. And then I think in a holistic environment, people will understand how important and this ADR is, and how beautifully it can tackle disputes, and without the heavy cost of litigation, without the time consumption. I think then only we can have a proper setup where people actually start opting for ADR, because there's no point of teachers training students for ADR when we do not have the demand in the field. And India, being a place where people generally get into education or professional education solely for the reason how much of an outcome they are going to get after the education, like what is the outcome they will get. So if I passion, I think, is obviously there, so I am not nulling the fact that there is no passion. People do get into profession for passion also, but then the hard reality is you need to have a earning out of it also. Until the time we tell the students that this is a lucrative field, you can earn a good amount of income from this also, and people are also aware that okay, if I go for litigation, I'm this is the cost I'm incurring, and if I go for ADR, this is more more lucrative for me. I think then only we can have very convincing environment for the students to get into it. And also the people who are opting for litigation as of today, when they get in connection with arbitrators or experts, they would understand, okay, the same problem can be solved by arbitration also, then why go for litigation? So I think it's both ways, that we need to understand the society also, and we need to understand it on an academic level also.
Right. Thank you, Shilpi. That's a very valuable perspective indeed. And I think all students can relate to this. Now, coming to the role of institutions, my next question is to Corrado. Can you please explain how do institutions like IAMC Hyderabad play a role in fostering mediation capacity building in India?
institutions in general and mediation providers can really play a key role. It is not just a matter of promoting and administering the mediation in the right way, which is paramount. So a mediation doesn't really start when the mediator and the parties meet in the mediation room, but lots start already before and at the time the requesting party and the responding party have the chance to get to know the mediation provider, understand what mediation is, and really the way you explain the parties what a mediation is, the way you welcome them, the way you assist them through all this bureaucracy can definitely change the tone and effectiveness of the mediation meeting when it will happen. So this is key elements of mediation providers, but it is not the only one. So they have another big role, or they can have another big one, of course, which is promoting mediation in general. So they become the house of mediation, where they host mediators, they host mediations, but they also are more visible than the single mediator. And so this main visibility they can have, and they, of course, can foster thanks to the quality of their work and the way they promote themselves, again, under the shade of quality, which is paramount again, and can make not just themselves and their mediators visible to the country, but also mediation itself. This is something that we really came to know here in Italy, where we had in the last 15 to 20 years a big change from mediation to be just on a voluntary basis to a state where we had, thanks to the European directives and the Italian mediation law, mandatory mediation. And this step was a big one, the promotion of mediation, but given how sudden it was walked, you really had a system where quality was not enough. Quality is never enough, I have to say. You always have to stay on quality. But at that time, when we had the mediation law entering into force, quality was lower than the one today. And so to give credibility to the system, the mediation itself, paramount was the high quality of some mediation institutions. I can quote the Milan Chamber of Arbitration and their mediation provider system, which were already very well established, very well reputed in Italy, and they very well took also this role of not just managing mediations and mediators, but also progressing on with the promotion, doing plenty of activity. And again, this is something that one mediator can't do very effectively, but a group of mediators within a mediation institution can really do. So paramount and fundamental role also with regards to that.
All right. Thank you, Corrado. That was very interesting. Now, I would like to bring the discussion to a multidisciplinary approach. Now that we have speakers from different backgrounds here, I would like to put my next question to Nikhil. Nikhil, do you think bringing together lawyers, engineers, and maybe finance professionals be encouraged for complex arbitration and mediation cases?
Thanks, Pallavi, for the question. Indeed. So in today's complex commercial disputes, especially like in areas like infrastructure, energy, and technology, we often encounter matters that transcend traditional legal boundaries. So these disputes require a deep understanding of engineering principles, financial models, and industry-specific technicalities. So solely relying on legal expertise is not sufficient any longer. In India, for example, with its rapid growing infrastructure and technology sectors, there is a pressing need for specialized ADR professionals who can handle multiple complex multidisciplinary disputes. Joint training programs can help build this specialized expertise, strengthening India's ADR landscape. Therefore, multidisciplinary training is not just beneficial, it's essential. It is the need of the hour. By fostering collaboration and knowledge sharing across disputes, we can enhance the quality and efficiency of dispute resolution. So recently, Arbitration Bar Association was established in India. So we need more such bar associations like mediation bar, engineering, so expert bar like claim consultants and other specialists which can help cater to the demands. And
Thank you.
as already other panelists have told that multi how we need to build an ecosystem, and I believe this is also a part of the ecosystem which is necessary.
I agree, Nikhil. Thank you for your response. And I would also love to hear the perspective of Shweta on this. As an expert, Shweta, can you please share your views on the steps that can be taken to encourage greater collaboration between legal professionals and industry experts for capacity building? Additionally, what international best practices can India adopt to enhance expert involvement in arbitration and mediation?
Thanks, Pallavi. It's a very interesting questions because I work as an expert on various arbitration matters. So we are required to have interface with the legal professionals to to help each other formulate the legal arguments and also to formulate the expert evidence so that it is easier for the law firms as well as the arbitrator to understand the complex matters. So that collaboration, that interface is always required. Now in my case, when I work on the arbitration matters, we usually hold joint workshops and we discuss on this specific or the maybe it could be a financial issue, it could be a technical issue, it could be a delay or the quantum issue. So where we sit together with the lawyers and explain these complex issues to them so that they are able to understand and formulate a proper legal strategy and their arguments in the claim documents, in the defense documents. Also, it is always helpful to have clients also in those meetings because even they are able to convey to us what are the issues which they had really faced on the project. So that collaborative approach is also always required between the legal professionals and the expert, and also we need to involve clients as well. Now, in order to do that, firstly, like I told you, we have the joint workshops while working on a case. But when we are not on a case, we still have to find ways to collaborate with the lawyers to have better understanding while working together in future cases. So one of the ways could be to have have the to engage in the joint projects or maybe case studies such as mock dispute resolution exercises. This is something which I have seen a lot on a lot happening in India. There are various legal professionals and the the technical experts or the delay experts. They are going to the universities and they're conducting these mock dispute resolution exercises. So that could be one of the ways. The other could be having the online platforms for collaboration. Like we always do a lot of seminars, webinars, or sometimes interviews also, wherein we call the industry experts from the legal background who are who are working in the arbitration and the mediation. Then we call the experts also who are always working on such kind of matters with the legal experts. So it is always better to have such kind of collaborations where they are able to share their insights, they are able to discuss certain issues, and they also seek advice on the technical and the legal matters among each other, among them. So that is one of the ways. Another could be like we can have a lot of networking events. Like in our case, our firm organizes a lot of networking events where where we are meeting with the law firms. They are meeting us. We are discussing on the latest developments which are happening when it comes to areas, or if there are updates in the processes or the new rules which are there. Like for example, I would like to share I'm working on some Russian matters. So it's very helpful when we meet the lawyers on such platforms because they know the legal side of what is happening on certain aspects as far as sanctions are concerned, because there are sanctions which are being imposed by EU on Russia. So that insight we get from the lawyers. Now when it comes to technical, we give them insight on how these equipments are being used here and there. So that kind of interface and collaboration is always helpful. So this is something which which India can also do a lot. So I think that answers your first question. The second question I think which you have asked is what best practices which India can adopt from when experts are involved in the mediation in the arbitration cases. There are 2 to 3 points which I can think of. Firstly, I would say early engagement of experts. This is something which we do not usually see in India. In international arbitration, experts like us, we are usually engaged in the early stages, where where the law firms or the clients, or for that matter, uh, we are required to assess the complexity of the dispute, so we know what is going to happen, what is the main crux, and what is the complexity of the issue, that we can see in the early stages. Now, this is also helpful in understanding the need for the expert hearings, also expert testimony also as well. So I would say early engagement is something which India can adopt, because I've seen in India the experts are engaged on the last minute sometimes. So it is very difficult to grasp everything to get understanding of the matter. So that I would say would be the first point. The second point which I could think of is again the training session programs for the experts. Even the experts need to be aware of the ADR processes and the rules which are there. So there should be a certification program, training programs for the experts itself, so that they are able to understand the procedural rules and about the latest developments which are happening in the ADR. So this will help in improving the quality of their expert evidences and ensure that there is proper neutrality and competence within the experts when it comes to different ADRs. So this is second. The third, which I could think of, is having proper expert panels. We might be having some expert panels in India, but like in international, we have a proper, proper panels wherein, the energy dispute professionals are listed, which are who are qualified in a particular dispute segment, maybe infrastructure segment. So like that in India, we can also have a proper panel where the experts are already listed. This is helpful in case of mediation and arbitration, because the tribunal or the mediators, they would have a list of the qualified or the experienced professionals, and they are able to select the experts as for the requirement basically. So this would be quite helpful. India can adopt all of these 3 points to have an effective mediation process and the arbitration process. Thank you.
Thank you for your response, Shweta. It definitely helped us understand the perspective of experts. And on this note, I would like to put my next question to Shilpi. Shilpi, as a professor, do you think interdisciplinary approaches, for instance, incorporating fields like psychology, would enrich the training of future arbitrators and mediators?
Again, that's a very good question. I, of course, psychology is one of the subjects which I think works closely with. If you need to understand ADR, I think that is one. But at the same time, I think sociology is also one of the subjects which needs to work hand in hand with sociology, psychology. Why? Because India is specifically a country where society plays a very vital role when you need to understand the background of a person, what are the belief system he's coming with, and per se, basically the upbringing or the background with which he is coming. And when you talk about psychology, what happens is a person's body language, the way he's processing his thoughts, the way he's putting up his tone or anything of that sort. I think body language per se, the way in which he's speaking, the way the gestures have been put up. I think an understanding of both of these fields will give students or experts a better idea of the person himself. And then obviously you can go ahead with whatever ADR technique you think suits best to tackle or deal with a person like that. If somebody who's coming from a very strong belief system, you cannot blatantly tell the person that no, I don't believe in these things. You need to be at par with the other person to understand and make him comfortable. As far as my understanding of ADR goes, I think people, the experts, arbitrators, mediators, they first need to connect with the client on levels where the client is comfortable enough telling them that okay, uh, this is my problem, this is what I want, this is the outcome that I'm expecting. And I think till the time we have that transparency or the comfort level between the clients or the students per se and the experts, I don't think ADR will really be something that they will go with if they don't understand the comfort level and if they're not able to share things like that. Because obviously there's a gap when we talk about clients moving into court. There is no connection, there's no control over the outcome, there's no connection as such, there's no comfort level, there's always a level of fear that they have that what might happen. you know uh, People are afraid of any outcome can come when you're moving into a court. But ADR, I understand, people, both the parties for that matter, the experts, they have a control over the process. And I think this is what makes it beautiful. Till the time you are comfortable with your client, till the time you're comfortable with the other person, and the other person is comfortable enough with you, and you understand the person's background, you understand the person's psychology, I think that will bring out the most beautiful relationship when you talk about client or expert. And that is when I think the most lucrative solutions can come out. Till the time you don't understand that what is the person wanting out of the process, I don't think. And it is more like, it's not like a win-win situation, or sorry, a win-loss situation where in a court one party is winning, one is losing. ADR is essentially when you are trying to make both the parties understand these are the points that you have with you, and we need to work out a solution. We need not fight for with one another. We need to sit and have a peaceful solution out of it. And I think till the time you understand both the sides of it, you connect with both the sides, I don't think you'll never be you'll not be sitting and taking out solutions. You'll rather be trying to make one party win and one party lose. So I think connection, per se, with the person's background, connection with the person's psychology, understanding the person will obviously help a lot. And university level, if I talk about, if the students in the very beginning along with ADR are taught about the psychological aspect, they're taught about the sociology and how the society is working, and pick up clues from these subjects, I think will polish by the time the student is in the fifth year or the third year, final years, will at least have an idea, okay, this is the society. And most probably when they are moving out of the college, they are moving into the society, they, when they pick up disputes or when they see disputes, I think the first thing that will click to their mind is, okay, this can be solved by ADR. But till the time you invite that into the student's mind and they're not able to connect to the subject, I don't think you can ever polish them or get them interested into the subject till the time they see any connection with it. So I think psychology and sociology are the two subjects which I think can work best when we are talking about ADR. And the importance of these subject along with ADR needs to be, well addressed to the students so that they connect whenever they're moving out of college. They connect to these disputes, and every day when they see these disputes around, I think the biggest achievement would be when they think of before litigation, when they think of ADR. Thank
And
you.
thank you for your response. And I think this is something that can definitely be explored with respect to capacity building in India. Now, I would like to put my next question to Corrado. Can you please share your thoughts on how can law firms in India effectively integrate mediation into their practice? And you can also always share your experiences of any successful models from your international experience.
Somehow this question refers back to the questions on university programs, because again, if you have lawyers which are not trained on mediation, which in fact do not understand what it is and how effective and different and appropriate it can be for disputes of their clients, what you risk to have, and we had it here in Italy, is some antagonism between lawyers and ADR in general, and mostly mediation. They don't understand, they don't use effectively. And so you don't really have the whole system working in the right way. But if you have conflict managers, first of all, you are not just restricting the lawyer's role to that of a litigator. It is much broader. I think it is also more satisfactory from a professional and personal perspective for lawyers, and they come into the role of the conflict manager. So when they have a client get into their law firm, they are much more able to offer a whole bunch of possible tools different from each other for being able to tackle dispute in the most effective way. Of course, you have litigation. But if they train and understand what ADRs are, they can, for example, offer mediation when there is a huge potential in trying to cultivating and reboosting relationships, both professional, commercial, interpersonal relationships, or if they really want to help the business, which is their client, to boost a kind of reputation, which is that of a business able to listen to their clients, to tackle problems in a creative way, and not just going to court. So if a lawyer is trained and understand what mediation is, and they are conflict managers instead of just litigators, they are satisfied enough from themselves and the way they can join their profession to offer a palette of possible solutions to their clients. And then, of course, it comes to mediation advocacy, which is the skills that a lawyer, if they are lawyers, who bring as counsels a client to a mediation table have for making the most out of a mediation. And of course, a mediation doesn't just mean to go through a process. It's not just objective negotiation, but as Shilpi was definitely well pointing out now, it is also a matter of coping with strong emotions, conflict roots, understanding how to communicate at best and make this constructive. And of course, a client by herself or himself can really face problems that each and every one of us face when into the eye of a conflict. So perhaps they can't make the best out of a mediation by themselves. And this is where a counsel who is a good mediation advocate can make the difference. Not just helping with tangibles, not just helping with technical or legal aspects of the dispute and the mediation, but also supporting the client from this perspective, more substantial and subjective perspective. So with regards to that, lawyers can really make the difference, can really boost the mediation towards success, can really have a more satisfactory approach to their profession. But again, it passes through training, understanding, and also understanding how, in fact, if they make all these happening, if they make good use of a mediation, their clients will be very satisfied. There is this kind of usual fear from lawyers who don't very well understand mediation and its value, that it can really make their profits to decrease. So if clients solve their dispute earlier on without going to court for years and years, they fear that they are not going to have the very same amount of money by the end of the month than if going to litigation, which is completely wrong. I mean, if they manage to bring their clients in the right way to mediation, first of all, in the very same amount of time of the duration of a court proceeding, they can really do plenty of mediation, so they can have more clients. And through mediation, clients can really get to a higher level of satisfaction that many times even a winning decision in court can grant them. And if you have a happy client, first of all, they will come back if they have another dispute. Many times it is businesses and they have disputes. And so if they get back, the lawyer can have once again the same client with a very strong rapport, trust, and professional trust. And then, of course, a client will talk about that very good lawyer to other colleagues, friends, entrepreneurs, fellows. And so it is a matter of boosting a lawyer's reputation and gaining even more clients. So, but it is all connected to well understanding what mediation is, practicing it in the very best way. So again, university training, post-university training, mediation advocacy, and the quality of supporting the client through mediation. And it can really create a more satisfactory approach to the legal profession, becoming a conflict manager.
Thank you, Corrado. That's very interesting. Client satisfaction is definitely important, and the idea of acting as a conflict manager seems interesting. I would like to now finally invite Nikhil to share his parting thoughts on the essential skills that young lawyers should develop. If you could just elaborate briefly.
Sure, Pallavi, thank you. So due to paucity of time, I'll just go with the skills. Firstly, a deep understanding of Indian Arbitration Act, Mediation Act, and international arbitration and mediation rules of institutions like ICC, CIAT are sine qua non. Then, ability to analyze the factual issues and legal issues, and in mediation, ability to collaborate is essential. And identifying what is ZOPA. ZOPA means zone of possible agreement. You have to have empathy in mediation. Other than that, moot court, debate, competition, and writing articles is merged. It enhances oral advocacy and drafting skills. I encourage students that they should develop an ability. Arbitration is adversarial and mediation is collaborative. So student must develop the skill to switch from one mindset to another. Lastly, be adaptive to technology changes. That is sine qua non for the present world. Thank you.
Thank you, Nikhil. I agree. That's indeed valuable. As we have now come to an end to today's discussion, I would like to thank our esteemed speakers for providing valuable insights into the importance of capacity building in arbitration and mediation. As India seeks to become a global hub for ADR, collaboration, specialized training, and adopting international best practices is essential. On behalf of MRP Advisory, I extend my heartfelt thanks to our speakers for taking the time to join us today. It was a lovely session, and we would look forward to staying in touch. Thank you. Have a great day.